our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, and welcome to the show. Today, we're talking about how to structure your business in order to avoid a contentious business divorce. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel and subscribe. You can find us on YouTube, Facebook, and X. You can also download an audio version of the podcast on Apple and or Spotify. Go ahead, download it, and leave us a review. We'd appreciate it. And you can find us at the handle @InRem Podcast on all of those channels. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is, what is Dodd-Frank and how does it impact seller carryback financing? So Dodd-Frank is a large piece of legislation dealing with Wall Street reform. And in that piece of legislation, there are provisions regarding seller carryback financing. So in addition to being a Wall Street reform, they actually took a step to go down to basically what I would describe as the little guy, the person owning a residential property who wants to sell that residential property on seller financing, and they put regulations in place over that type of transaction. So basically, Dodd-Frank is going to apply anytime you want to do seller carryback financing to a buyer who intends to reside in the property. So if the buyer is an individual who's going to take title as an individual and intends to reside in the property, Dodd-Frank will apply. Dodd-Frank doesn't apply if the buyer's an LLC or if the buyer does not intend to reside in the property. They're purchasing it as an investment property, etc. But if Dodd-Frank applies, then there's certain restrictions and requirements that you have to comply with. So if Dodd-Frank applies and you own a property and you're going to sell the property on seller financing, and you're an individual or you own it in a revocable trust, so like an estate planning trust, then in that case, you can do one seller financing transaction basically once every 12 months and not have much restriction or regulation. And so, obviously there's usury and other laws you have to comply with. But for the most part, there's not much restriction under Dodd-Frank, and you're kind of free to set the financing terms. You don't have to confirm that the buyer is going to be able to satisfy the loan obligations or anything like that. The next exception under Dodd-Frank for seller financing to an individual who's going to intend to reside in the property is through an entity such as an LLC or a corporation. And in that case, you can do seller financing up to 3 times every 12-month period, but you have more restrictions. So the main restrictions, there's others, but the main restrictions are the loan has to be fully amortizing, which means that there can't be any balloon payments. And second, you have to make a reasonable determination of the buyer's ability to repay the loan. We had Jeff Watson on about a month ago now, and he's actually working on and lobbying for legislation that would lift that restriction from 3 transactions every 12-month period to over 20 transactions every 12-month period, which would give basically real estate investors a greater ability to fall under this exception, but they still have to comply with the loan terms. If you're going to do 3 in a 12-month period, or on your 4th that you're going to do during that 12-month period, you can do it. You can do seller carryback financing, but in that case, you have to bring in an RMLO, a residential mortgage loan originator, properly licensed, who is going to then work with the buyer/borrower and underwrite the transaction. And you have to go through them for that transaction. They will do all the required disclosures that they have to make to the borrower, and confirm the borrower's ability to satisfy, obtain all the information they need from the borrower that way, and then confirm that the loan terms are adequate and appropriate. So even though you may fall under Dodd-Frank, and you're not going to qualify for any of the exceptions, then in that case, you can still do a seller carryback transaction as an investor to an end buyer who is going to buy it in their individual name and intend to live in the property. You just have to underwrite it through an RMLO. So just know Dodd-Frank is out there. It does apply, and you need to comply with it on your seller carryback financing transactions.
All right. Thank you, Sean. With that, a few announcements for you, the listener. Join us every Tuesday at 2:00 p.m. Arizona time for the Creative Finance Collective. That is an opportunity for us as lawyers or professionals in the space of creative finance to get together, talk about all things creative finance related, talk about what different states are doing with respect to laws and regulations in creative finance. And we just work together to try to make each other's forms and practice better in order to better serve you, the investor. If you're an investor, however, that's watching, not only is it a good opportunity to learn more information, it's an opportunity for you to engage with the members of the collective. It's an opportunity for you to ask questions. In fact, we make ourselves available for the entire hour, 2 questions, and we're there until we stop getting questions, and then we move on. So it's important for you to engage with us and be there and have your questions, whether you're kind of a seasoned investor and you're running into particular problems that you're trying to iron out, or you're a newbie coming in and you just want to understand what are the pitfalls, the risks, what should I expect going into this that I'm not hearing from maybe a guru on YouTube that's just talking about it. I want to hear what lawyers are saying about this and understand, the different angles as I approach creative finance. So make sure to join us every Tuesday at 2:00 p.m. We would love to have you and enjoy engaging with you. With that, we're going to go ahead and get to our topic today. Today, we're talking about business divorce. And not only are we talking about business divorce, and maybe this is a new concept for you, maybe you've not heard the term business divorce. We're going to explain what that is, but also explain and talk about ways to structure your business in order to avoid business divorce. So with us to discuss that topic, we have Todd Lenczycki. Todd, I butchered your name. Sorry about that. Our own CPA lawyer. How you been?
I'm doing well. And again, thank you for having me on here. Todd Lenczycki, the CPA Attorney.
So tell our listeners, I know you've been a guest on the show, maybe the most popular guest. So very few listeners would have even forgotten this. But tell them how you became the CPA attorney and what your practice focuses on.
Yeah, absolutely. And I appreciate the kind words. And I do want to send out a plug for your podcast. Not only investors, I've listened in a couple of times, attorneys, just hearing what other attorneys are doing or moving forward on that thing. It's a great resource. Again, ask questions. So I'm glad you guys keep doing that. But about myself, I'm Todd Lenczycki. I am the CPA attorney, www.thecpaattorney.com. How I became a CPA. I first became a CPA first. I went to Arizona State University. I loved doing accounting. I was an auditor. I did some tax work. Did that for about 5 years. And I learned that it was fun. I enjoyed it. But maybe being a lawyer would be a little bit more exciting, a little bit more day-to-day action. So I went to law school, and luckily I got accepted and passed the bar exam and became an attorney next. And being a CPA and an attorney, I am exposed to a lot of different financial issues, whether it's people fighting over finances or people trying to structure their finances. I have really the best of both worlds. I understand it from both perspectives. And what I've been telling my clients lately, and I think they seem to appreciate this, is because I'm a CPA, I'm very financially conservative. So, I'm not going to charge you as much as maybe some of these other attorneys out there or something like that. So I got that going for me as well.
All right. And your practice primarily focuses in Arizona and California. Is that right?
Correct. So I'm a licensed attorney in Arizona and in California. Mainly Southern California is where I'm located, but I have done things all throughout the state. I'm licensed throughout the state, and my practice is mainly in litigation, so handling things like a business divorce that we're talking about, but I also have the transactional background, whether it's in real estate, tax, or something like that.
All right. So let's get into our topic here. And maybe for the new investor, or maybe even the seasoned investor who hasn't run into this concept of a business divorce is a blending of two different worlds, business and maybe family law. And they're like, I've heard of divorce, but this idea of business divorce, what is it? Well, lawyers that are in the space of business divorce and have practiced in that area can know it can be a pretty brutal topic and one to be aware of. So why don't we start here? Why don't you just describe for our listeners what is a business divorce?
Sure. So a business divorce is what I always explain is essentially it's a dispute within the partnership or a dispute within the business where the members themselves are fighting. So more often than not, it's a very successful company or a company that's just about to become successful, or maybe it's even a real estate contract between a couple different investors where they set up an LLC or something like that, where the business is successful, but the partners decide for one reason or another that they can't get along with each other anymore, whether it's a money dispute, a power dispute, or a decision that needs to be made. The attorneys are called in, like us, to basically say, look, we want to keep the business surviving because that's where everyone's making their money, but we got to figure out a way where you guys either have to play well together or one of you guys have to go and they're properly compensated for leaving for all the work that they've already done. So where does the name business divorce come from? Well, it's a business that's successful and it's a divorce because the partners are essentially splitting apart.
You've listed out a few things, examples, but tell us what are the most common things that you see or disputes that you see resulting in this, business divorce situation?
So, like I said, most of the time it's a fight over money. It's a fight over, how money needs to be distributed, how money needs to be spent. It's also, I'm sure we're going to get to this, it's a fight over the powers of the company were never properly decided in the beginning, so that now when something pops up, either side, both partners have their own idea about how things should go, and they basically dispute about it. Another common way that you see this is when you have a majority owner. So they already have worked things out where one person has the majority, has the power, but the minority shareholders or the minority owners decide, you know what? This isn't fair to me. I'm being treated wrongly because I don't have the power. I don't have this. And then they get upset and they start making a ruckus to saying, look, this is my company too, even though I might not be the majority owner. I have a say in this. And, most of the time they get overrun, but it's a lot of hurt feelings, a lot of assets in dispute. And that's where I think the divorce aspect comes into it, is it's personal feelings and it's personal thoughts of, I think the company should go this direction when it's actually going the other direction.
What I think is really interesting is when you kind of set up the preface of the business divorce and what it is, you really didn't explain a scenario where the business was in the dumps and doing terrible. You actually describe common scenarios where it's really doing well or even about to just explode. And, from an outsider's perspective, you would think that's a time where everybody's just on cloud nine. Like, we've hit it and we're hitting it. everybody's getting rich. What on earth is there to be upset about? But it sounds like success just manifests or even creates more of a problem than just being in the dumps, just trying to make a business survive. Is that kind of what you've seen?
Yeah, and I think that there's that adage, right? More money, more problems is kind of is what happens in these businesses. So you brought up a good point. What about when the business is in the dumps? Why don't you see it as much over there? And the reason why is there's really not that much to fight about. I'm doing one actually right now where the business is in the dumps, and it's just basically, well, what are we fighting about? You get this, I'll take that, and we'll be done, and we'll go our separate directions. There's nothing to really, maybe there's some intellectual property, maybe there's a website or something, and you're not really fighting about it. But it's when there is money, when there is success, I think people get greedy. People maybe start doing things where where can I get my share of the money, and your share is not as important, and I'm going to start treating you a little bit differently or something. And that's where the problems erupt. And that's why the successful ones, and also people have the resources to fight it. Normally if things are in the hole, people are just going to cut their losses and go their other way. When you're fighting about multiple digits, millions maybe, people have the resources to say, it's maybe worth my while to get another $500,000 and spending on an attorney that will cost me a percentage of that. But, I see the way. I see the way to make this work financially.
Let's say you have owners that are in a dispute. They don't like each other. And they come to you and say, Todd, say one owner comes to you and said, Todd, I either need to be out or that other person needs to be out. What is the process? I mean, how do you look at it and say, okay, what can we do to resolve this, and where does it go from there?
Yeah. So the first thing you always do is you look to the writings of the company. You look to the articles of incorporation, the articles of organization. Usually those are pretty generic. There's nothing going to be in there. What you look to is the operating agreement. If it's an LLC, you look to the bylaws if it's a corporation, and hopefully they have them. There is the scenario where there was never formed that direction, where they have those things. So then you go to the statutory default. So in Arizona, we're very lucky that we have the LLC Act that was recently amended and added in there. It follows the Uniform Act for the most part, where you'll have these standby provisions that you can use that basically say companies should operate this way unless overridden by the operating agreement. So getting to your question, Sean, what would I look at is, first of all, you talk to your client, you find out exactly what's going on, you figure out what the problems are and what they want as the resolution. And then you go to the actual company writings, the operating agreement, and you say, what does that say about the issue? Are we talking about disbursements not being done? So then you look, well, when are disbursements supposed to be made? And sadly, what you maybe find is there's these operating agreements out there, and they're either well written and the people that come to you don't remember what they agreed to already, or maybe they didn't understand what they were agreeing. So then we got to follow the rules of what the operating agreement says. Or there's the alternative where they're poorly written. And that opens up the idea of, well, what did it mean at the time when we signed this? What was our implications? What do these emails mean along with it that go and explain things? So what I always tell my client is, first of all, tell me what's going on. 2, give me the documents that we're going to rely upon, that we'll look in there and see what our rights are and see if they match with what we're trying to do. And getting to the next question, probably, well, what do you do when they're not? What do you do when the majority owners aren't doing what they're supposed to do? Well, that's exactly what we have here. You have redress according to the operating agreement. You have to file a lawsuit. Or what I always do, I'm trying to be a conservative CPA attorney. I try to talk to the other side. A lot of what can be resolved can be done with bringing the sides together and seeing if there's a resolution that can be done and an amendment to be made or something to that regard. I'm getting ahead of yourself, of your question probably, Sean, but that's what I would do. I would ask if the other side is open to discussion is probably the first step instead of filing something right away.
Now, and we'll get to this, issue as far as buy sale and buyout provisions and stuff like that. But I will say, I really like your approach. I remember a case that was turning really contentious, and this seemed destined for a lawsuit. And the attorney that I was working under at the time, he went to our client and said, "Hey, look, let's give it one more shot. Let's go back to the other side." The other side was represented by counsel. "And I want you to give me a number that you would be willing to pay them for the business and to buy them out, but you would be willing to take to be bought out," because it was 50-50 ownership, right? And we put it together. We thought for sure that we were going to buy them out by making this offer. And we submitted it. And within a day, we got a letter back, "We'll buy you out." And we did the paperwork. They bought us out. Our client got the money and they went on to their next venture. And we even put in the letter that way, which is, we can either buy you out for this or you can buy us out. But it was what I liked about it was the level of fairness, in that, because you had to be willing to take the buyout yourself, because we see a lot of times with negotiations, you lowball and then people are offended and upset. Is that kind of what your style when you go and try to negotiate with the other side, is to try to, take a fair approach, but still get the resolution, especially in a business divorce case?
Yeah, absolutely. I always think if the attorneys from both sides or the clients from both sides can talk to each other, and they can talk to each other early on, a lot of things can be solved. And what you're describing, Sean, is a great example, a shotgun buyout where, leave it, take it, or do it. And it forces you to be fair. If I'm going to lowball them, they're just going to buy me out at my lowball number. And the reality is these two people or groups of people used to get along. They came up with the idea to make this business successful, or they were relying on each other for the resources to make this business successful. So it's not like we're talking about people that, were already bitter enemies or something that would be in a car accident or something. These are people that have a relationship and have that prior relationship, like a divorce, like a husband and a wife. They're bound together now by their legal arrangement to make good of it. And, the reality is, and there's a bunch of attorneys on this teleconference right now, a really contentious business divorce, the only people that really make money, sadly, are the attorneys. Everyone else gets the attorney bill in the mail. They get probably a resolution that they're not 100% happy with from a court or from an arbitrator. And they're just upset. And they have 2 years of their life that was thinking about this day in and day out. So, if you can resolve, and you can resolve early, that is always the thing. And luckily, if you're an open-minded attorney, there's a lot of other open-minded attorneys out there that if you show up with something reasonable and your client likes it, you're going to solve it. I likely lately, and this is something maybe to say about society, I've had more resolutions in the past 2 years at an early on discussion than I've had at an actual case. Very few of our cases, as you all know, very rarely go to a trial or an arbitration. They're usually settled. And the earlier you settle them, the easier it is. So, luckily a lot of attorneys are cooperating lately. Maybe I'm just getting lucky. I don't know.
Well, let's say that, they hire you and you do everything you can to negotiate a resolution, and it's just not happening, and something has to give. The business cannot continue operating under the status quo, and so it's lawsuit time. Obviously there's all kinds of different ways to plead these types of cases, but what are some of the common claims that you see business owners make in dealing with business divorce?
Yeah. So the most common claim is obviously breach of contract, breach of the operating agreement. It's not following the ways that it's supposed to be going, breaches of promises, whether they're outside the operating agreement. There's the statutes that you can rely upon, again, more to the breach of contract thing, but you also see the breach of fiduciary duties or the breach of duty that's owed between partners. I know that's a issue of contention depending on what state you're in. Again, you usually look to your operating agreement, see what kind of duties are owed, but you'll have that breach of duty claim in there. You'll have your statutory claims, you'll have your breach of contract claims. Those are the primary ones that I've seen or that I would file. You can always do the other ones, unjust enrichment, as fallbacks or specific performance to something, or a declaratory judgment to try to get something moving. If it's a really big thing and you're the minority or you're someone that should have a lot of power and you don't, and you see the business crumbling, you can always ask for a receivership, something to that regard where you're actually asking for immediate court, I call it injunction or something to make a decision. And, it just all depends on the timing, how quick do we need to get this done? How much, how is the business operating still? Can it operate in this current state? And that all dictates a lot of this.
What about dissolution action?
That's another thing. So a dissolution, just to kind of take a step back, is you're basically saying we're going to dissolve and wind up the company because, technically under the statutes in Arizona, if you can't agree on something and you're at a deadlock and, it's a major issue or a major thing to be decided, dissolution is on the table. So dissolution is basically saying we're going to liquidate everything or we're going to wind down the company or split it up in a way where, it can be split between the two partners. And that's the way we're going to decide this is, split the baby, so to speak. I've never really seen a dissolution action taken all the way to the end. It's usually threatened and then you find a way around it or something to that regard. The best way, you always got to look to your operating agreement though. You always got to look to see what's available under there and what does it allow you to do. And dissolution is usually an option.
What are some of the common issues that the court might decide throughout the litigation? There could be a fight. There can be a fight over money, but as you mentioned before, it might be a fight over power. It might be a fight over control, and control is the lifeblood of a business, right? A business can't, even though it's a separate legal entity in the eyes of the law, without humans to run it, it's nothing, and it does nothing. So, who's in place to be able to propel it forward and have that control matters. But explain to some of the issues that a court might be faced with in deciding throughout that kind of litigation.
Yeah, so absolutely. I think what I've seen is the judges are mostly concerned with, one, what immediately needs to be done in order for there to be something to split later on. Usually you have one side or the other saying, look, this major decision needs to happen in the next 60 days. And, we need that to be done. And under the operating agreement, we're allowed to make that decision, or, we at least have a 60% vote to do it, or, we don't have it. We're at 50-50. We're at loggerheads. We're at a deadlock, jump in court and make a decision on what needs to be done. So what I've always seen is there's an immediate, especially in Arizona, I keep on going back to Arizona, that's where we all are. We have what's known as the commercial court. And the commercial courts in Arizona handle these specific business disputes and a lot of other different types of disputes involving businesses. And they have rules in place that say, look, you got to talk to the other side as soon as something is filed. You got to get in front of me and have a status conference, and we'll set one on an expedited basis, or at least soon enough, where I want to know all of the major issues that are time sensitive so that we can make sure that this survives. So what I've seen the court do, at least in my experience, is look to both sides to say what needs to be decided now, what can be kicked down the road to later, and then let's get something in place, whether it's an immediate, some type of hearing or evidentiary thing to decide that, or do we appoint a receiver or somebody or a neutral to take charge so that the business survives?
So when you have, let's just say you have 50-50 ownership. So you have the two owners that are fighting, and then you have this business that is of concern. That's a going concern. It's its own separate, entity. And of course, the owners generally will have their own attorneys. Does the business have an attorney?
That's a good question. Usually one of the owners takes charge and tries to represent the company as itself, whether they think they're the majority owner or they have been the majority owner, they'll try to represent the business. But it technically correct, the business can have its own attorney, but there's going to be, if you're at loggerheads and you're 50-50 on deciding what's a transaction for the business to take, you're also going to be 50-50 at loggerheads about deciding who the business attorney is going to be. So 9 times out of 10, you're not going to have an attorney step in there because they'll have no engagement letter to base themselves on, and they can't trust who can represent, who gives them the authority to represent the business. So most of the time I've seen where it's usually 2 separate counsels representing the 2 separate partners, and one may quasi say the business is mine, so let me represent it, but it's usually the partner dispute, and who represents the business is kind of cast to the side.
So as you know, I spent about 2 years practicing business divorce, and it was rough. I mean, it was a very taxing experience for me as an attorney, probably the 2 most stressful years practicing law that I've ever had. Just because of the fact that the emotions run so high on this stuff. I would show up and I'd have all these voicemail messages from overnight where people, like, literally the clients are thinking about their case all night long. I'd have a bunch of emails overnight, and, you can imagine the stress that takes, because it's, this is so important, so emotional. Talk to us about the emotional toll that these business owners go through during this divorce, either proceeding or dispute.
And I've never practiced family law except for a few months as an internship, but that's what I understand family law is. It is their life. It is their blood. It is their sweat. It is their money. It's their livelihood. So a business divorce is like their child. They're fighting over their child. They're constantly thinking about it. They're constantly thinking about, look what this other side is doing to my business. Look what this is happening because they just won't play fair or do the right thing. So you're exactly right. It's a lot of holding your client's hand, telling them that things take time, or tell me what really is important and we will solve that now, because you can't have an important thing and fight about this all the time, or you're going to be paying me or the other side or both of us a lot of money. And, if that's the way you want to do it, that's fine, but it will take a taxing toll on you. And a lot of times when I am at that settlement table, hopefully early on, I will tell my client that, maybe we're not getting what we fully want here, but think of all of the emotion and resources that you are going to pump into this on a mental and spiritual or, emotional side, not just physical assets. Do you want that? And what I'm seeing is a lot of people will say, no, I don't. I want to be done with this. And this isn't a perfect scenario, but I will take it because I will be done. And finality, I guarantee, I tell every one of my clients, you will love finality. You will love the fact that when you wake up the next morning, this is over. And I guarantee, I never say this, but I almost always get the email the next morning or the next phone call where it will say, Todd, I am so glad this is over. Yes, this was the right thing. And then I know when I follow up with them 6 months later, they're always moved on, and they put all of that worry and effort and thought process into their new venture or whatever their new idea is that spawned off from the business divorce. And they're so much happier. So finality and emotion is clearly involved in these business divorces, that if you can get a handle on it and your client can handle that better than most, you will do better than most.
Well, let's jump to the beginning then. We've talked about the dispute side. It does not sound pleasant. Sounds like something you want to avoid. So what are some common mistakes that business owners make in either forming the business or even operating the business that results in these types of disputes?
Exactly. So how does this dispute erupt? This dispute erupts because one, it was never discussed about this future problem that could erupt. More prior planning prevents poor performance. I always said that. So get everything in writing, get something written down. You need an operating agreement. LLC law in most states allows you to proceed without an operating agreement. You need an operating agreement, and you need an operating agreement that you have read, that you understand, and you get what happens when these situations erupt. And what's great about an operating agreement is you can write whatever you want in there, as long as it's not patently illegal or against certain things that you're probably not going to, as long as you're fair and reasonable, you can write any terms in there and solve any problems in advance. And I get it. How do I think of all the problems that I'm going to have in advance before I have them? And that's an impossible task to perform. But can you at least think of some of them? Can you think of a position where if you are a 50-50 partner, what happens when you are deadlocked? Come up with an idea, and write it and get the other side to agree to it, and then follow through with that idea. And if this is the best thing about operating agreements, they can be amended. So if things change, your company changes an aspect where your operating agreement, get everyone back together while you're still cooperative and change your operating agreement to match what you guys all are thinking and get it in there. Because I guarantee you, when you guys are all on the same page, you'll come up with a masterpiece, and that will be very good for you. But when you're all on the same page and you think you're all on the same page and you don't actually write it down, when you get to a problem, whoever's on the other side of the problem is going to forget about that conversation and remember the conversation they had where it favors them. And then boom, that's where you have the fight.
Todd, I remember as a young kid when I was getting married, we were taking premarital counseling, and the pastor said to me at the time, if I could give you any advice, is don't have any preconceived expectations of what you expect your wife to do. Because, in his experience, a lot of fights and consternation came from a spouse failing to meet these expectations that you had in your head. And whatever drove those expectations, there could be a lot behind it. But it seems to me in the business context as well, so much of this is, well, one, personality, but two, failure of the other person to meet whatever expectations you had. Maybe that was because you thought you had a conversation about something or whatever else. And what you're saying about the operating agreement and putting this down is flesh this out in writing, right? Remove, unreasonable expectations that the parties might have about what they're each going to do or how hard they're going to work or whatever else that's going to look like. Boil this down. Do you think a lot of it just comes down to the failure to just hash this out, and then they just collide into the future because of these unmanaged and unrealistic expectations?
Yeah, I think you described it pretty well. It's just things will happen. People grow apart. People have different ideas as things move along. I have LLCs set up with partners of mine that we can go a year at a time without talking to each other because it's just a simple project that it's being worked on. But for others, that doesn't work. You need to have communication. So yeah, an operating agreement where you have whether you write down what you need everybody to do, or at least write down what as you said, if you have a very strong expectation, it's a little bit different than, I guess, marriage. You should probably have that expectation flushed out in the beginning to figure it out and see if it's something that can be written down so that there's no dispute about it later. And writings and operating agreements are key for businesses. And grab one off we're all lawyers here. Grab one off the internet and tailor it to what you want to do. And if that's not good enough for you, or your company is going to be more successful than that, call one of us. Let us design your operating agreement. There's plenty of good lawyers out there that have forms and things that they could throw in there, and they'll make you think about stuff that you haven't thought about already. What do you do when someone wants to leave? What do you do when someone dies? What do you do when someone wants to give their interest to someone else? All of that is just kind of basic 101 stuff for us business attorneys, but you'll be surprised. A lot of business partners don't talk about that. So those are the discussions you need to have when you're cooperative to get it at least an understanding of what everybody wants.
Well, and just not to belabor the point of the operating agreement, but another thing I think that businesses forget about as they grow is the operating agreement is not this one and done thing forever, right? I mean, it's important that you do it, and it's good that you did it, but you don't have to put it on the shelf and it be gone forever, because when you started that small little business, things change. You add partners, you remove partners, the business gets bigger, it buys land, it does whatever it does, but it's not going to ever, if it's staying the same, it's dying. So the businesses are growing. And I think a lot of business members, they forget about this operating agreement. It's like if you did an estate plan and your kids got older, you added kids, you'd go and amend it, right? You'd go add this kid, you'd revise things. I think a lot of folks forget to kind of document the status of things, the meetings that they do along the way as well. And I wonder how much that adds to the problem as well.
Oh, yeah. Well, when things are good, things are good. There's no problems. You sail along and you just keep doing what you're doing. It's when things turn or things change or people have different, like you said, life events happen. New partners come on. New partners go away. It's just, it all needs to be amended and looked at. Like you said, I think, Andy, you said it well. It's not a document that's put on the shelf, never to be seen again. It's a living document that needs to be revised and updated so that, you can get things just as strong in the past as they will be in the future.
So when Andy was talking about the expectations of, partners and couples and stuff, I thought he was actually going to go a different direction. So I'll kind of go that way. But one of the things that you always hear about in LLCs is sweat equity. I have my sweat equity. I don't have to put in money because I put in my time, energy, and effort. And a lot of times business owners go in with an expectation of you bring the money, I bring the skills and resources, and they have this expectation. But then one side doesn't meet the expectation of the other. How do you, number one, how's sweat equity handled as far as like capital contributions to the entity? And then second, how do you deal with, sweat equity in an operating agreement or any type of, contract related to the business?
Sure. So that's a great question. Sweat equity needs to be handled because basically an operating agreement shows you the ownership percentages. An operating agreement, when you really boil it down to it, you can throw out all the other provisions, but it basically boils down to who owns what, who owns, who gets the money when it comes in, who has to pay the expenses when they go out, who splits the profits, who gets to vote on things, and everybody has their different powers at different percentages. So sweat equity needs to be determined on, well, what does that actually get you? Does it get you a 35% ownership interest? Does it give you a fluctuating ownership interest based upon hitting certain goals, working certain hours, doing those type of things? So as long as you can define it and decide it, you're going to be in a much better place. But if it's simply, we're going to have a 50-50 ownership and I provided all the money and you provided all the work, it is what it is. Whatever that work ends up being, they got 50% for doing it, and you're going to get trapped if you're the 50% money. If you're the 50% owner that contributed all the money, you better darn well know what's the sweat equity that's giving the other person the 50%. And if they don't make it, you got to challenge that early on so that they don't end up owning a 50% interest in the company for doing whatever they did.
what are some, we've talked about the operating agreement. There's also a buy-sell agreement, which I've referred to as the premarital agreement for owners of LLCs. But what are withdrawal, or we use the legal term dissociation provisions, that you can put in an operating agreement or a buy-sell agreement that would hopefully resolve a business divorce without it being contentious? Meaning, yeah, maybe you're going to go your separate direction, but the agreement says how you're going to do it, and the parties just do it. You know, what are those types of provisions? What do they look like?
Yeah, so the buy sell or the buying a partner out provisions are usually set up in a way where when one partner wants out, they basically, you go to the operating agreement, and what you'll commonly see is that partner can leave, and he can give his interest back to the company or back to the majority owner, or they're split back up against all the other owners and prorated to the percentage that they owed. And usually what you have set in there is a fair market value price. So what is a fair market value price? You know, you can define it. You can agree in advance. Hey, it's going to be 3 times whatever our taxable income is, or it's going to be, we're going to hire an appraiser and he's going to go out there and use this valuation metrics, and he's going to come up with the value of the company, and your 20% is going to be 20% of that. And that's what you're going to be paid over time, or all up front, or whatever. What you usually will see also in there is, when you're doing an LLC, it's probably a close group of members. There's going to be restrictions on you being able to sell your 20%. So can I just go out to Sean St. Clair and say, guess what? I own 20% of this lucrative company. Here you go, Sean. You're going to buy it from me for $100,000, and you're going to be the new partner. Well, the LLC, usually the standard operating agreement says, no. You're not going to be able to do that, Todd. You're going to have to sell that 20% back to us, and then we'll get to buy it, whether it's under these terms, or maybe it's something like, if you're going to sell it for $100,000, we get a right of first refusal to buy it at $100,000. So you come in with your offer, Todd, and we'll match it, or if not, we'll let Sean in, and he'll be the 20% owner, usually under some kind of restricted area where he won't be able to vote. He'll just get his 20% interest or whatever. But yeah, these are the exact things that you'll see in a standard operating agreement of, when somebody wants out, either voluntarily or possibly involuntarily, we want to put somebody out, we're able to buy them out. That usually doesn't happen, though. Usually you have rights that you can't be involuntarily put out, and there's ways to stop that as well under the law. But usually you'll see a provision in there, and it just defines what fair value is and pays you out, and you're done and you're out.
So you would recommend against a provision that allows the other owners to buy out one owner who they just, not a bad person, they just can't do business with them. It's like,
you can have that. I mean, it's you can write it in there. It's perfectly legal. The problem that you're going to have, though, is whatever formula that you decide that buyout has to be, if it ends up really drastically underestimating the true value of those shares of the 20% owner getting kicked out, he's going to file a lawsuit against you, and he's going to go for fair value. And there's probably a very colorable chance that he could win that lawsuit too. So at least if you're going to have a buyout provision where you can kick people out of your company, at least say it's going to be fair value. And then come up with a method of determining that fair value that, at least on its face, is reasonable under the time. And just know, if it ever becomes unreasonable, you better rewrite it to become reasonable again.
What about for cause termination or dissociation provisions? And we've seen this. You've seen it, where somebody basically embezzled or used company funds for personal gain when, you're not supposed to do that. They're just a bad actor. They're stealing from the company. They're engaging in, wrongful conduct that's damaging to the company. What does that look like? The for cause dissociation or termination?
It's usually the same way. There's some kind of formula in there to just get rid of the bad actor so that the company can flourish. Obviously, if you have a bad actor that's causing the company to lose value, you need him out of there. And if he's an owner as well, it's not just like an employee that you can just terminate and at will and get rid of. You got to get rid of his interest, or at the very least, I've seen provisions where it says his interest just becomes a distribution only. You're no longer allowed to make votes in here. We can basically disassociate you. But, usually you'll see the same type of provisions of when we have for cause, we can buy you out. And then, yes, that makes it a lot easier, to make a determination. I guess what I'm looking at is I'm fighting the involuntary kick out of the minority owner that doesn't want to be kicked out and they're not getting enough money versus the bad actor kick out, which I think you could probably, at least a court or a neutral will go along with it of, look, it should still be on some type of fair value at the time, but subtract out all the damages that he's done to the company, the costs of actually kicking him out, and some kind of workable amount can be done. Can you just not give him anything though? Yeah, I wouldn't do that. I wouldn't have your provision say that just because you're a bad actor, you're out, because that's not going to fly well. It's not going to be considered fair and reasonable. I don't know where I'm getting this fair and reasonable idea from. I don't think it's technically in the statutes, but just from what my experience, it seems like something that would be required.
Todd, since we're talking about disputes, one thing that you can contract in and often is in an operating agreement is alternative dispute resolution provisions. There's a lot of different takes on ADR provisions, how those play out. I've seen ones that I like, and I've seen ones that I hate. I guess two questions. Do you like to plan for alternative dispute resolution? And if so, how do you like to set that up? Do you have a preferred way that you like to see that?
Sure. So I'm actually on the side of, I don't like the ADR provisions. I don't like the mediation provisions, because the way I always look at it is, if I really want to do those things and I think it's going to be helpful, you can always suggest them later. If we don't have an ADR provision in our contract, but you go to the other side and say, look, we have a dispute about this. We really like this arbitrator and we think he should decide it because he's going to decide it within 90 days and it's going to cost us less money. Let's do it. The other side can agree to arbitration at that time. Forcing a binding arbitration on someone always seems a little bit too much, but you're right. It's the common thing, what you see. So I have no problems with it. Obviously arbitration is supposed to save you money as long
what about non-binding mediation?
I don't think that really works. But what I have seen, which I like in operating agreements, is some kind of provision in there where before you can file a lawsuit, you do have to do some type of buyout offer that you're willing to either buy out the company at or take something at. It's tough when it's a minority person because obviously they shouldn't be allowed to buy out the company. But I've sseen things in there that say, instead of filing a lawsuit, you will be offered this amount for your shares. And if you agree to it in advance, they can just do that and get you out of there. It's almost like a dissenter's rights provision almost, but just really short circuited so that it resolves a conflict before it happens. But mediation works. I mean, don't get me wrong. Mediation works when the lawyers are close to reaching a solution, but you're just not there. But if you really just have a contentious dispute and you're trying to get thrown into a mediation, a lot of those mediators are good, but they're just not that good. That's all.
And a lot of times it's only going to serve to increase the fees involved.
Exactly. But, I'm always open to listening. If I'm ever on a case against you, please call me and discuss it, because I am willing to listen to anything for my client. And I expect in return for the attorneys on the other side, because the cases that I have done that have gone to the final dispute in front of a judge or in front of a jury or in front of an arbitrator, it always seems to end in a way where my client is happy with the result, but it could have been better. It's never 100% of what they wanted. And it always seems like there's some type of split there that could have been resolved earlier had we just all talked about,
What do you see beyond what we've talked about here, operating agreements, buy, sell, a lot of the front end documentation, and maybe this is part of it, but what do you see at the end of the day as really being the biggest mistake on the front end that leads to contentious divorces in business?
Not understanding what you're getting yourself into, not understanding the rules and the laws or what your agreements say because you signed something not understanding what was going on. So, not to build up our business, but please, before you sign any document, whether you're selling your business, going into a business, talk to an attorney about it and just make sure that your ideas align with what those documents actually say. So my response to you is make sure you know what you're getting into, and then make sure that it's operating and going along the way it's supposed to, meaning that as soon as you see something going not the way you think it should be going or not in the way that the operating agreement says it should be going, you got to bring that up and get it back on the tracks, or amend the operating agreement to make the tracks go the direction they need to go. But it's just being open and honest and seizing the opportunities of when you're still cooperating to make everything better. That's the way I look at it.
Now, Todd, when you mention when you start seeing things go the way they're not supposed to be going, how often is this driven due to the fact that one owner really didn't do the due diligence on the other partner on the front end like they should? Maybe they jumped in with somebody they didn't know enough about. You wouldn't, when a lot of money's at stake, you wouldn't think you would do that. But early on in a business, it's all about ideas and there is no money. So maybe you're not thinking about that. But how do you ever see that where somebody really should have just done a little bit of due diligence?
Absolutely. Yeah. Know who you're getting in partnership with, know your partner. That's a great thing, Andy, is you got to know who you're dealing with. And I get it. You can only do so much exploration and you can only look into so many things, but it's going to save you stress and worry in the back end when you know your partners well, because the better you know your partners, the better you can solve these problems before they become problems. I'm sure Andy and Sean, you've had issues, but because you know each other so well, you can solve them and you move on, and I know when me and Sean worked together, we would be working on cases, and granted we're on the same side or something, but we would talk about things and, bounce ideas off of each other and come up with a good plan and things get better. So the more you talk to your partners, when you do see something that comes up that doesn't seem right, figure it out then before it becomes a mountain, keep it at the molehill size and get beyond it.
Well, Todd, we thank you so much for joining us. We really appreciate it. It's great information. Tell our listeners how they can get in contact with you.
Yeah, absolutely. So the best way to reach me is by email, contact@thecpaattorney.com, or my website, www.thecpaattorney.com. I am, like I always say, one of the attorneys. I'm sure you guys are. I pick up the phone when it rings. So call my number. I will answer it. If I don't, I usually call you back right away. And I got some people working for me. They help answer the phones as well. But usually if you have an issue, we'll be able to discuss it rather quickly.
All right. Well, thanks for being with us, Todd. We enjoyed it. Let's do it again soon.
Yeah, absolutely. Thank you to both of you, and enjoy the rest of your afternoon or morning, whatever time you're watching this. Have a good one.
All right, Todd.
Thanks,
we'll
Todd.
see you. With that, everybody, that is our show. Make sure to join us next week. We'll see you then.
Have a good day, everyone.